Today it's our 11th week. We have just 2 weeks ahead now. We are almost at the end of the program. I'd like to thank you all for coming here. Today we have a prominent figure from Belgium, perhaps, right? Assimakis Komninos. He's also a friend of mine. We held a conference back in 2009 in Istanbul. I know him from those dates. I'd like to thank you for coming here. We will talk about the Article 102 and European Court of Justice cases today with him. Let me just introduce him to you. As I said, he's a prominent figure in EU competition law, especially he's known with his trial skills. He represents clients before European courts, the European Commission, national competition authorities, national courts, and international arbitration tribunals. His highlights include representing Google, Android, and Eureka cases, Amazon in the Italian carve-out case, and the list goes on. Turning to his education, he has an LLB degree, undergrad degree from the University of Athens, Greece. He has 2 LLM degrees, one from Trinity College, University of Cambridge, the second one from New York University, United States, and he has a PhD from European University Institute, Italy, Florence. So, and he's currently a visiting professor at University of Pantheon, Assas. And he's a member of the Executive Committee of the Global Competition Law Center at the College of Europe. He's also a writer on legal matters and often gives speeches and seminars in EU law. And if I'm not mistaken, other than these cases, you are also expert on private enforcement, right?
Yes. Absolutely.
Your PhD was about the private enforcement of EU competition law. So I thank you again for coming here. We are very grateful for you to host you. We're very happy to host you here. You have 40 minutes. Afterwards, we have a Q&A session of 15 minutes. Floor is yours.
Very good. Thank you very much, Cem, for the invitation. It's a great pleasure to be again in Istanbul. It has been 10 years since my last visit. I used to come more often, but over the last 10 years, unfortunately, we were too busy or things were happening, so it didn't happen. So when you told me that there was this opportunity, I was extremely happy to say immediately yes. So, as Cem explained, I would like to speak about some Article 102 cases. Article 102 is essentially my area. You know, this is what I do mostly in Brussels these days. I work a little bit also on the digital markets and the Digital Services Act. But then when it comes to antitrust, Article 102 is my kind of favorite subject. Some of these cases I have pleaded myself. I will explain that, you know, I will give my views about that, but, you know, take what I say with a pinch of salt because I'm a bit prejudiced when it comes to those cases. I'll start with a more general, let's say, observation on Article 102. Over the last years, the Court of Justice of the EU has made a very important let's say, shift in its jurisprudence, in its case law. Whereas before 2017, the court was relatively quite, I would say, conservative and not so, let's say, open to the economic analysis of Article 102. It had already started, I would say, in the early 2010s, and certainly with the Intel case that I'm going to describe now, it had its own revolution, and it started to be quite positive vis-à-vis economics and abuse of dominance. So in 2017, we had a major shift. That's September 2017, the Intel judgment of the Court of Justice, and not just of the Court of Justice, but of the Grand Chamber of the Court of Justice. The Grand Chamber the court sits in its grand chamber composition relatively rarely. And the fact that we had a grand chamber judgment gave more kind of importance to this shift, let's say. Now, over the years, since 2017, the court, has changed a bit again its position vis-a-vis Article 102. Usually with the Court of Justice is 2 steps ahead, 1 step, let's say, I recede for 1 step, or maybe it's 1 step, you go ahead and then you recede for a couple of steps. That's usually the case. But I have to say the Intel revolution of 2017 is still certainly something that marks the court's case law. So how did this all start? So the Intel saga, let's say. This is an old case. It's 2009, 2009 decision of the European Commission, Intel, the chip maker, which gives payments to customers, original equipment manufacturers, computer makers, essentially, and some retailers that sell computers, essentially. And these payments, these rebates, have an exclusivity kind of condition. And therefore, the European Commission takes a decision, says these are exclusivity payments. I think according to the case law, the old Hoffman-LaRoche case law, you can go immediately to hell, let's say, because, you have had these agreements, and these agreements are per se, so to say, although there is no such thing as per se abuse, but let's say by object, not even that, but, presumptively unlawful or something like that. However, the European Commission says back then, even if I do not need to do that, I will nevertheless spend 200 paragraphs in a decision of a huge kind of length and explain also vis-a-vis using economics principles, essentially, why these rebates are bad, why these rebates are anti-competitive. These are the years, 2009, I remind you, when the European Commission had issued its guidance paper on Article 102. And these economic test, which is called the as efficient competitor test, was in that guidance paper. So the European Commission wanted essentially to sell better its guidance paper by applying the economic test to that particular type of conduct. So the Commission says, I don't need to do that, but I will do it nevertheless, and you will see that these rebates are anti-competitive. Intel, after the decision, goes to the General Court, the first instance court in Luxembourg. The General Court brushes aside the application for annulment, says, that's clear. These are rebates which are considered to be presumptively unlawful. And Intel appeals to the Court of Justice, and then we have this famous judgment. Before the court's judgment in the EU, before the Court of Justice, we have a person called the Advocate General. The Advocate General is somebody that is giving an opinion, essentially, and then the court may or may not follow the Advocate General. The Advocate General here happened to be Wahl. Back then, he was an Advocate General, Niels Wahl. And Niels Wahl was probably back then the only person, although this is put in the YouTube, so I shouldn't be saying that, but perhaps one of the few persons in the court that understood economics and competition law. So Wahl issues an opinion and says that's nonsense. This case law is wrong in the sense that it misinterprets earlier case law, and therefore, yes, we should have a full-fledged effects-based analysis for Article 102. And then we go before the Court of Justice, and everybody waits to see what happened. My understanding is that there was a lot of discussion, let's say, at the Grand Chamber. And although the court maybe was going in a certain direction, and for example, if you read the first part of the judgment, which is about other things, about extraterritoriality, etc., if you go to the second part of the judgment, which is about the rebates part, you will see that the two parts may not necessarily fit well together, which I kind of translate as a kind of probably something happened during the délibéré, as we say in French. Something happened during the discussion of the case. And my understanding is that not sure what I can be saying again, but let's say something had changed between the first draft of the judgment and the final draft and the final judgment in this case. That's what anecdotal evidence suggests. We can talk about that later on. And then the Court of Justice takes this decision, essentially, which introduces economics into Article 102. I would say, for those of you that have not read it. It's only 15 paragraphs. This huge revolution happened within 15 paragraphs. You have, for example, paragraphs 133 to 135. This is about the fundamental principles about 102 and the exclusionary. These are general principles. 137, 140. This is about the basic framework for exclusivity and quasi-exclusivity rebates. This is the most important part. And then 141 to 147 is the application to the facts of this case. The second part, this is the most interesting part of the judgment. So the general principles, you have the insufficient competitor principle, which was already kind of confirmed by the Court of Justice in an earlier judgment, post-Denmark 1. So the court says that Article 102 is not about protecting competitors which are less efficient. And therefore, if you have, in other words, pro-competitive foreclosure of competitors, that is okay. We do not intervene. We need to have anti-competitive foreclosure of competitors. Indeed, they say not every exclusionary effect is necessarily detrimental to competition. And then you have, again, the old kind of the old mantras like the special responsibility of dominant companies and so on. This is the most important part of the judgment. So in those two paragraphs, the Court of Justice has brushed aside 30 years of case law. However, the Court of Justice is not like other courts, for example, maybe in the UK or certainly in the US, where they say explicitly that they are changing the case law. The Court of Justice in Luxembourg hates admitting that it is changing its case law. So they always try to fit what they are deciding with judgments in the past. So if you read the first paragraph, it says, this is the old case law. That is the old case law that, when you have an exclusivity rebate or indeed exclusive dealing and all that, then this is anti-competitive. That's the old case law references to Hoffman-LaRoche. And then in 138, there is this famous phrase, however, that case law must be further clarified. This is like the joke, so to say, among competition lawyers, the Intel clarification, essentially. In reality, we have a total revisiting of the old case law, but the court put it, let's say, in those mild terms, and this is the clarification. And what is the clarification? The clarification is that this case law is valid. We are not essentially setting that case law aside. This is still valid, but this case law means that the undertaking with a dominant position can come during the administrative phase of the case and on the basis of supporting evidence, show that its conduct was not capable of restricting competition and producing the effects. In other words, the Court of Justice says, yes, that's the case law, but the dominant company can disprove it, essentially, can come forward during the administrative phase and bring evidence that shows that this is essentially not anti-competitive. Careful what the court says. The court does not speak about a presumption. The court does not use the word presume, presumption, etc. The court doesn't even say disprove. It doesn't use the word disprove. It says where the company concerned submits during the administrative procedure on the basis of supporting evidence. It doesn't say strong supporting evidence, on the basis of supporting evidence that its conduct was not capable of, etc., etc. In other words, the court is saying this is not really a hard presumption. It is quite easy, essentially, to disprove that principle by bringing forward evidence. That is the point where the court essentially changes its case law. And then the judgment continues. It talks about the specific elements. If the dominant company brings forward evidence, these are the elements, paragraph 139. These are the elements that the competition authority must examine. If we look at all these elements essentially all these elements are the effects-based analysis. This is the all circumstances test. This is the effects-based analysis. That's what effects-based analysis means, essentially. All these elements. And then the court continues and says, you need to do all this analysis, and only after an analysis, and then you can make the balancing of favorable and unfavorable effects on competition. In other words, you can balance the anti-competitive effects with the pro-competitive effects, objective justification, efficiencies, etc. But that balancing can happen only after the above analysis of the intrinsic capacity of the practice to foreclose competitors, which are at least as efficient as the dominant company. That makes it extremely clear that here we have a different type of test when it comes to Article 102 exclusionary abuses. Then the judgment then applies this new law, let's say, to the facts of the case, and the judgment says, look, in this particular case, the commission spent like 200 paragraphs in its decision on the sufficient competitor test. And you, General Court, you said, oh, I'm not going to review at all the commission's exercise of its discretion during that, let's say, analysis, because I don't need to. But if the commission has done that, then surely you should have taken that into account, precisely because Intel had put forward these arguments that we talked about before. The case then is sent back to the General Court, and the General Court reviews for the first time the sufficient competitor test, and the General Court annuls the commission decision. I can tell you it is very rare for commission decisions to be annulled. This was one of the very rare occasions. This was the first time that a big bunch, let's say, of a commission's legal theory of harm had been annulled since the 70s. We had some small cases where we had partial annulments on this or that, but in a major case, we have to go back in the late 70s to find an annulment of an Article 102 decision by the European Commission. In fact, one of the former chief economists of the European Commission had made a study, and he had said that the success rate of the European Commission before the European courts was, before Intel, 98% or something like that. So we would never see the Commission lose an Article 102 case. That's why all the lawyers in Brussels back then, we were extremely excited with that judgment. So I want to continue. The slides are, of course, there. The General Court then says that that was a mistake. It goes through the test, the sufficient competitor test. It discovers the various mistakes, the various errors made by the European Commission, and in the end annuls. Another thing which was important was the coverage rate, how much part of the market was covered by that particular practice. That is something that where the Commission decision was not at all clear. How, the Commission has put its theory with regard to the importance of specific customers. That's another important point. So the General Court annuls the biggest part of the Commission decision, which is about the rebates. The Commission further appeals that judgment again to the European Court of Justice. These, unfortunately, are the vicissitudes of EU litigation. This case started in 2002 with a complaint of AMD before the European Commission. Still, we have an Intel case pending before the Court of Justice. So it's like the quarter of a century judgment, the quarter of a century case, but it is what it is. So the Commission appeals again before the Court of Justice. And here the Court of Justice clarifies a bit the clarification, so to say. And the Court of Justice says, look, what the ECJ meant, what the Grand Chamber meant before, it's clear to us. It means that you cannot rely on some other case law, which is called the Knauf case law, and say, you know what, Commission, I'm defending a case before you, but I am just going to sit still, and I will tell you, just see you in court. You know, I'm not going to defend myself. I will see you in court, and I will defend my case before the court. The court says that this is not the case with Intel. If you want to put forward arguments that relate to the full effects-based analysis, that you need to do during the administrative procedure. So the court clarifies the clarification in a procedural way. It says you can put forward such arguments. You can essentially go for a full-fledged effects-based analysis, but that you need to do before the administrative authority during the administrative phase. Another thing which I find quite interesting is that the court does not use the word presumption. There are lots of academics who believe that there was a presumption in Intel 1. The European Commission currently interprets Intel 1 as a presumption-based judgment. I have always disagreed with that, and I think there is a bit of support in this Intel 2 judgment of the Court of Justice where the word presumption is not used, as opposed to the General Court, which had used the word presumption. It's a soft presumption in any event, but the Court of Justice in Intel 2 does not use the word presumption. Again, the court does not distinguish between exclusivity and other loyalty rebates. That's clear because for all rebates, we have the all circumstances test, full-fledged effects-based analysis for all rebates. It stresses the fundamental condition of coverage and, of course, says that the AC test, which is hated by the European Commission and some competition authorities, most competition authorities, is generally a tool that should be applicable when it comes to rebates. So this is the Intel revolution, so to say, which has changed fundamentally the case law for Article 102. Let's see what has happened after Intel. This was about rebates and exclusive dealing. As you could say that it applied also to exclusive dealing because of paragraph 139, yes, if I remember well. But we have had lots of other judgments afterwards. Google Shopping. Google Shopping is not a pricing abuse case. It's a behavioral, let's say, case. It's a non-pricing case. You are familiar with this is where we had the famous self-preferencing theory of harm, which was introduced. The judgment of the General Court, which confirmed the Commission decision, in my view, was more problematic than the ECJ judgment. Although, I mean, to be very clear, I have represented here an association which was supporting Google. So I was on the other side. But clearly, I mean, I can live with the ECJ judgment as opposed to the General Court judgment, which had many problems. Essentially, one problem was that they were using extraneous concepts or concepts which are a bit nebulous, let's say, like superdominance. Superdominance has never been used in ECJ case law. Only one advocate general in the early days had used the word superdominance. And in any event, in this particular case, the European Commission had not used the word superdominance in its decision. So the General Court finds these terms, superdominance, for example, very important. Then the General Court speaks about a general principle of equal treatment, which is a general principle of EU law. and therefore it binds dominant companies. I think that was going too far. The good thing is that it says that leveraging is generally neutral. Leveraging is not bad by nature. You can have pro-competitive leveraging or anti-competitive leveraging. But in this case, it was, let's say, illegal. And then you have some elements which I find particularly problematic. Here, the General Court says conduct involved a certain degree of abnormality, a certain form of abnormality. What is normal and what is abnormal? I mean, we are entering a very subjective kind of area. And then here, the General Court says Google changed its conduct. Initially, they were kind of, they had a different way of showing results, and then they changed, they introduced certain algorithms, etc. Yeah, okay, things change. You can't, especially in this dynamic industry, you can't have the same conduct always. And then the court says, we know that the European Commission is telling us that Bronner, the old case law of Bronner on indispensability, etc., does not apply. And I think the Commission says the court indeed is right. The Bronner test does not apply here. But even if the Bronner test were to apply, we would have considered that it is fulfilled. The Bronner conditions are fulfilled here because this is indispensable, essentially, this type of traffic. It's indispensable for the comparator shopping services, essentially, that compete with Google. So this is appealed. It goes to the Court of Justice. Again, Grand Chamber. And the court essentially corrects a bit these problematic elements that I've described before. So it says that, to me, the court more or less says that this is a discrimination case. Article 102 covers also discriminatory abuses. So we have conduct which is not competition on the merits, and at the same time, this particular conduct is capable of causing anti-competitive effects. They follow the all circumstances test. So this is effects-based analysis, clearly. I mean, this is an effects-based analysis case. And luckily, paragraph 186, as I say, kills the principle of equality. The court doesn't go into equality and non-equality, etc. This is gone. There are some good references to the principle of causality, that there has to be a causal link between conduct and anti-competitive effects. And paragraph 266, although here it's a kind of obiter dictum, but still it says that the AC test must be applied in cases where it is relevant. Here, however, the court says it's irrelevant because this is not a pricing abuse case. Android, I will go through quite, because of time constraints. Android is the biggest fine ever imposed by the European Commission. I was involved here. I was representing Google. The case was about 3 types of agreements. One was about tying, essentially. The second was a kind of very specific form of tying. And the third was about exclusivity rebates. Before the General Court, Google won on the exclusivity rebates part of the case, because the court found that the Commission had made errors on the as efficient competitor analysis and test. However, the General Court confirmed the Commission's decision when it comes to the tying part. What was the tying part? This was about the pre-installation condition that essentially, you had to be already pre-installed in all Android phones. Now, the pre-installation condition was not really an exclusivity condition, or if you want a default condition. It was merely to be pre-installed, which means that you could also pre-install other competing tools like search apps and the browser essentially apps. You could have other competing ones, but the court, relying upon a lot, I would say, of behavioral economics, essentially says that, well, in reality, once you're pre-installed, there is a bias, essentially, for consumer bias, and therefore that's it. In other words, the court implies that the competitors of Google should have been given the opportunity to conclude agreements of exclusivity, excluding Google altogether from its Android system, which is quite remarkable if you think about that. We had a 5% reduction of the fine before the General Court. The case currently is before the Court of Justice. We had the hearing in January. On the 12th of June, Mrs. Cocotte, the Advocate General, will deliver her opinion on the case. Lithuanian Railways, that's a very interesting case. There is the Lithuanian Railways former state monopoly. They compete with other railway companies, and there's a question about a big oil refinery, for example. And they have this agreement with the oil refinery, how much the oil refinery will pay for the state monopoly, the former state monopoly. And, there is some degree of negotiation, and then the customer says, oh, I could perhaps go to your competitors. I could use this particular railway line that connects the network with the Latvian network, and I don't need you if we don't find a satisfactory price here. And what the Lithuanian Railways does is they go and destroy the connection between the Lithuanian and the Latvian railways, essentially. In other words, they destroy their own property. Why they destroy their own property? Because they wanted essentially to teach a good lesson to the customer who wanted to switch, right? And that case is a good example of no economic sense case, essentially. This is essentially the point where the Court of Justice has relied quite a lot. So, of course, Bronner, the court says, doesn't apply. It's an independent form of abuse, no economic sense, again. And at the end of the day, there is a regulatory regime, the court says, relying on Slovak Telecom. And therefore, if there is a regulatory regime, you should not be, you don't have the right to refuse access. And therefore, in other words, the indispensability condition of Bronner will not apply to you. Servizio Elettrico Nazionale, that's a great case, a big case before the Court of Justice. Again, this is an Italian preliminary reference, very theoretical and academic questions asked by the referring court, the Italian Supreme Court. What is the purpose of Article 102? Whom does Article 102 protect, and so on? This is a case where, unfortunately, we had a judgment which says anything, everything, and at the same time, nothing, as I say. Why? Because there's on the one hand and on the other hand. There are lots of elements here, and these elements are self-contradictory. So, for example, just to give you an idea, I mean, let's go to the positive, let's say elements. Consumer welfare, says the Court of Justice, is the ultimate objective of Article 102. Juxtaposing the positive with the negative. However, we need to have an effective competitive structure. And there are references to the pre-Intel formalistic case law. So you have two things at the same time in the second paragraph, essentially. On the one hand, it's consumer welfare, but at the same time, we need to protect an effective competitive structure. Of course, we need to have a focus on capacity to foreclose, likelihood of effects, all circumstances, and what's the test? The test is departure from competition on the merits plus exclusionary effects. But no evidence is admissible if it shows that there were no actual exclusionary effects. And the fact that you don't have actual exclusionary effects cannot really put in question the likelihood of effects, because, there is an argument that if the conduct has been going on for a number of years and there have been no anti-competitive effects, maybe this rebuts the presumption that this rebuts the likelihood of effects, let's say, because they haven't materialized for a number of years. The court says that's fine. We don't need that. There are some other confusions essentially in the judgment, but I think this particular judgment was not great. I mean, it was not great, and I think the fact, the nature of the preliminary reference questions from the Italian court did not help here. Unilever Italia is another great case from, again, coming from the Supreme Court in Italy. This is about exclusive dealing. I'm just being very swift now because of time constraints. Essentially, the question in Unilever Italia was, does Intel apply to exclusive dealing, or is it only about rebates? If you read the judgment, you will see that the court is saying, of course, it does apply to exclusive dealing. That's clear from the judgment. I mean, I have the slides. You can check them out. Of course, when it comes to the AC test, that particular judgment goes even further. Here, it was not a pricing case. It was an exclusive dealing case. So what the economist, by the way, the economist here, I understand, was Cristina Cafara. So what the economist did in this case, the economist went before the Italian Competition Authority and said, look, this is an exclusive dealing case. There's no rebates. There's nothing about that. However, how much should the competitor pay the customer in order for the customer to breach the contract and go to the competitor, relying on an effective breach of contract analysis, the Yale Law School economic analysis of law. In other words, everything has a value. It's not about rebates, but how much should the competitor pay the customer for the customer to switch? So they constructed an insufficient competitor test on that basis. They submitted it to the Italian Competition Authority. The Italian Competition Authority said, no, I don't want to hear about that because this is exclusive dealing. The AC test is completely irrelevant, etc. And the Court of Justice, when they heard about that, they said, sorry, once they're putting forward arguments before you, you need to listen to those arguments. Funny enough, this is a case where you would read it and you would say, okay, Unilever won here. And the Servizio Elettrico Nazionale is a case where you would read it at the ECJ judgment. You say, okay, Enel here lost. But when it comes to the reference, when the case went back to the Council of State in Italy, Enel won and Unilever lost. That's the crazy situation in terms of the dialogue between the European Court of Justice and the national courts. That's a very interesting case. My case, I pleaded it before the General Court. Here we had for the first time a full annulment of a commission decision because the commission, according to the General Court, the case is currently under appeal, obviously, according to the General Court, the commission essentially made a number of errors of appreciation when it comes to the facts of the case. I would say this is not a very interesting case in terms of the legal theory behind that. It has more to do with how do you analyze the facts and how you put the facts next to the law. There are some interesting questions, but because of the pendency of the case, I cannot comment currently. Facebook, you are familiar with that case. The big question here is, can a competition authority or should a competition authority take into account GDPR, data protection laws, for example, when it applies competition rules? Or is competition law totally independent of regulation, for example? The Court of Justice says, absolutely. The competition authority can take into account other laws, other regulations, for example, and in other words, other regulations can inform its competition analysis. Of course, we need to be careful. The competition authorities are not enforcers of the GDPR or of the data protection rules. They are enforcers of the competition rules. So the GDPR angle has to inform the competition analysis, cannot substitute the competition analysis. European Super League, for those that like football, this is a case essentially which, for us, the kind of hardcore competition lawyers, we would never think that in the European Super League would become a case for the competition law textbooks. However, this is how the Court of Justice does it sometimes. The court decided to do essentially a nice clarification of the Article 102 case law along with the Article 101 case law in this case. So one particular point was, I mentioned that before, the two conditions, conduct going against competition on the merits and anti-competitive effects, likelihood of anti-competitive effects. Are these conditions cumulative, or they are essentially or, connected by an or? Because in Unilever Italia, they had made an error when they were writing the judgment. They said or. So there was a huge theory, oh, it's an or, which means that you can either have a conduct against competition on the merits or anti-competitive effects. No, it's clear. If you read that paragraph, it corrects Unilever Italia and says these are cumulative conditions. That's one thing. Very interestingly, the court refers again, after many years, after Michelin 2, if I remember well, to the concept of abusive behavior by object. So there is a question now that do we really have abuses by object? Before European Super League, I would say we don't. These are exceptional cases. But now, after European Super League, it seems that we do have abuses by object, and these are naked restrictions, abuses that go against the single market, and it seems that restrictions of this kind, essentially, which completely kill the possibility of any competitors getting into the market. The most interesting thing in European Super League is that at some point, this is about private conduct. Of course, these are the associations, the sports associations, and they are quite powerful, but this is about private conduct. And then at some point, the court starts, paragraph 132, to speak about Article 106. Article 106 is the article that deals with special undertakings, which are state undertakings or have a special or exclusive rights given by the state. And Article 106 decisions are addressed to the member states, not to undertakings, right? So they go through all this case of Article 106, and then suddenly, out of the blue, in paragraph 137, they say, requirements identical to those recalled in the three preceding paragraphs are all the more necessary when an undertaking in a dominant position through its conduct and not by virtue of getting granted special or exclusive rights, etc., places itself in a situation where it's able to deny potentially competing undertakings access to a given market. If the dominant company has such a position that controls access to the market, the court says, and here UEFA, FIFA were in such a position, we will apply to those undertakings the rules that we apply to member states. Right? This is very interesting. And then it says, see to that effect judgment of GB in BM. This is nonsense. That particular judgment has nothing to do with that. By the way, for those of you that like to read judgments of the Court of Justice, these are nice words. You should always be careful. When you see in a judgment of the Court of Justice the words see to that effect, the alarm bell should start ringing, because it means precisely that the reference has nothing to do with what the court wants to say, and we have new law here, essentially. The Court of Justice always hides new law with the words "see to that effect," voir en ce sens. When you see those words, immediately the alarm should be off, because we know that there is something new coming from the Court of Justice. So this is very interesting coming in European Super League. Towercast, this is about mergers. I will not say much. This is about the question whether national competition authorities can review through Article 102 consummated mergers that have fallen, let's say, below thresholds, below the radar. And the Court of Justice says, yes, they can be reviewed. I never had a doubt about that, but the French Competition Authority believed that it didn't have the jurisdiction to do that. Google AdSense, I will just leave aside. This is a general court judgment, and I will finish with Google Android Auto, a judgment of last February. And in fact, I have to leave very early tomorrow because I'm moderating a panel at the GCLC at noon in Brussels on this particular judgment. This judgment signals the end of Bronner and of the refusal to supply case law indispensability, etc. In my view, it signals the end of Bronner for all cases. Some commentators read this judgment as applying only to digital platforms. I don't think this is the case. If you read the judgment, it's pretty clear. So if you read, for example, what the conditions that the court uses, it says Bronner only applies if the infrastructure was developed by the dominant company solely for the needs of its own business. Okay, so, you know, I construct something only for me and I don't share, fine. And is owned by that dominant company now as we speak. So I'm sorry, but these two conditions mean essentially that, you know, in the modern economy, you know, it's very difficult to construct facilities just for you, you know, and if, of course, you construct facilities that just for you and they're not in the market, there will never be a question. Nobody will come to ask for access in the first place, right? So essentially, this kills Bronner, in my view. And I don't think that Bronner anymore applies in the abstract, I would say. Now, okay, there may be some very strange cases in the old economy where perhaps it may have something to do, but for me, it's kind of clear. I will stop here because I've already taken a lot of time, but I'm happy to discuss if you have questions. It was a very quick kind of bird's eye view on Article 102, but I'm happy to address questions.
Thank you very much. Komninos. Okay, now, do we have questions from the floor? Okay.
Thank you very much for the presentation. I would like to hear your thoughts with regards to draft guidelines of the European Commission on exclusionary behaviors of dominant undertakings. It seems that the draft guidelines moves away from a facts-based approach and adopts more formalistic approach based on certain legal presumptions and kind of shift the burden of proof to the defendants' undertakings. So I would like to hear your thoughts about that. Thank you.
You know, I have been a bit, let's say, provocative when it comes to the guidelines because on the 30th of August, as I was finishing my holidays, I published an article, I published a blog in Brussels, and the name of the title was J'accuse the European Commission. I accuse the European Commission is moving away from the effects-based analysis, and I can tell you I have received a lot of criticism and calls from the Commission on that particular article. But I still believe that the Commission, with its new guidelines, certainly goes more formalistic, let's say. That's clear. Well, what is the formalism? There is no reference to theory of harm, for example. You read these guidelines, no reference to theory of harm, no reference to consumer welfare. Instead, you have a lot of categorizations. There is this category, which is like presumptions. There's the other category, which is like the soft presumptions. They're calling them now the soft presumptions after the debacle and all the criticism. And then there's the third category, which is full effects-based analysis. And how do we categorize whether that particular conduct goes into hell or purgatory or paradise? Oh, we look at the external characteristics of conduct. I'm sorry, this is what the formalistic approach is about. You should not be looking at external characteristics of conduct. You should be looking at theories of harm. What does it mean, a certain conduct, what does it mean in terms of theory of harm? What's the theory of harm here? External characteristics means nothing at all. We go back to formalism. So these categorizations are extremely, I would say, extremely bad. Not to mention, for example, that okay, I mean, this is just a joke, but, it's not the most important thing. But, at the beginning, they say, yes, it's possible, we cannot exclude that you may have a dominant position with 10% of the market. I mean, I'm sorry, this is completely, this will go, obviously, because they threw it as a kind of, the commission usually does that. They throw something far, and then everybody concentrates on that, and the more important stuff, they forget. But we should also be looking at the more important elements here. So for me, they really need to rethink the whole approach. They need to concentrate again on theories of harm, consumer harm. What is consumer harm? With regard to the AEC test, etc., fine. I knew that they would try to kind of suppress it a bit. They cannot totally kill it because of the case law, but I think they're trying to suppress it. I don't have fine. I was expecting that, but I didn't expect the complete departure from notions such as consumer welfare, theories of harm, and so on. That I didn't expect. So definitely, I'm not happy at all with that.
And what about the reason of this change? I mean, in general, is it just to lift the burden of
they want to make their lives easier. They've lost cases before. They were kind of spoiled. I mean, they were winning all cases before the courts. That's clear, and they started losing cases. To be fair to the Commission, it is true that with this latest case law, it's extremely difficult for competition authorities and the Commission to bring pricing cases. Pricing cases are extremely difficult. Behavioral cases, non-pricing, that's fine. Right? The court is there following the Commission. There have been cases where maybe, it was a bit, but, there are ways to deal with that. There are ways to deal with that. For example, you can introduce and focus on qualitative elements, for example. You can say, yes, but if we have, for example, selectivity elements in the way you're giving your rebates, for example. You select your customers according to their strategic importance that they represent for a particular competitor, etc. You look at coverage, etc., etc. And then you can say, sorry, I'm not going to apply necessarily the insufficient competitor test and numerical tests when I have all these other qualitative elements. That they could have said, but, so I can see why they're going there, but I think they've gone too far, I think.
Okay. Generally, we tend to think that the formalism brings predictability. I mean, what is illegal, what is abuse. At least it's easier to say because you look at the nature of the behavior, right? But given the complex nature of these categorizations, do you think that this it will serve to this?
There has always been a bit of tension between the effects-based analysis and legal certainty. Because legal certainty, when do we have legal certainty? Legal certainty we have with per se rules of permission and per se rules of prohibition. There you have absolute legal certainty. But the economics and economic analysis is not about legal certainty. Economic analysis is about, flexibility. You need to have, you need to hire good advisors or good economists, etc. That's what the economic analysis is the difficult road. The easy road is per se permission, like we had in the US before Lina Khan, or per se prohibition, like we had, for example, in the old days in Europe. So there is always a bit of tension. But at the end of the day, this is competition law, and it's a very technical way. It's a very technical area, and yeah, it can be difficult. But that's what. Otherwise, you will have many type 1, and there's a famous question of how many type 1 or type 2 errors do we want, and I think we should have a balance on these issues.
All right, thank you.
Thank you very much for the presentation. It was very informative. When I see the cases, I was asking whether there is a coherent trend in the approach of the Court of Justice.
Yeah.
Maybe in pricing decisions like rebate, it seems that it favors effect-based approach, but on the other hand, regarding refusal to deal, it seems that it is conditions to find an abuse. Do you think this is because of the nature of the infringement or abuse, or court is also not, doesn't know what to do actually, which approach it should adopt?
It's somewhere in between, let's say. Let me put it this way. There are some friends of mine, academics, who say that, there is always a common line in the case law, a fil central, as we say in French, a common kind of way the case law develops. And in other words, there is a computer in the dungeon in the Court of Justice headquarters in Luxembourg, and the computer, checks and controls everything. And this paragraph in this judgment is there because of that paragraph in the other judgment. And the court is saying this there because it is connected with something. It doesn't work like that. The case law moves in haphazard ways, unfortunately, sometimes. That's the way the case law, there is no central computer in the dungeons of Rue du Fort Niedergrundwald 32, whatever the address is of the Court of Justice. There's no central computer. It's very much fact-based. It's very much, what the judges, how the case has been argued, how the commission has argued the case, how the parties have argued the case, which was the juge rapporteur, which was the referendar, which was composition you had, were you in grand chamber, etc., etc., etc. And then you see, I showed you the see to that effect. It doesn't work like that. However, yes, we can say that indeed, if you look at how the court acts in pricing cases, there is a bit of dichotomy now between pricing and non-pricing cases. Pricing cases, the court certainly has espoused fully the full effects-based analysis and the numerical tools and so on. In non-pricing cases, like tying, like self-preferencing, and so on, I think the court there is more conservative. And this is due to the fact that mistakenly, again, I think, for the court, economics is numbers. So, pricing is about numbers, economics. That's not the case. Economics is not only about numbers. Economics is about incentives. Economics is about, many other areas, not just numbers. But that's a different story.
I have another question, more specific question. You said that after Android Auto, Bronner will not have any place to be applied. I was wondering, Microsoft case, do you think in that case, the Microsoft developed maybe the know-how or technical knowledge for just its own use for Explorer? So it didn't want to share it with its competitors. Do you think in that case we can still say that Bronner case could apply to
the Microsoft case was a bit different because there it was not a refusal to supply case, it was a refusal to license case.
Yes.
So it's a bit different, let's say. What the court said there is that you have the primary market, which is Windows essentially, and you have a secondary market where Microsoft in reality has its own products and therefore they are competing products, etc. There, Microsoft had not shared interoperability information with anybody. Right, you're right when it comes to that. They had not shared interoperability information. And indeed, there you could say it's the first time that, I was involved in the Microsoft case. It was my first case when I was working as a lawyer. And the big issue there was this new product criterion, because before Microsoft, according to the McGill and IMS Health case law, you needed to prove that you are refused, and yet you are bringing into the market a new product. And we were saying back then in Microsoft, but this is not a new product. The product already exists. We have the product. Actually, ours is the best, and they just want to imitate. They don't want to innovate in reality, but the court didn't go there.
Thank you.
Thank you very much. I'll have two more questions.
Well, thank you for the presentation. It's always a pleasure listening to you. I'll steer the discussion away from technical details and ask you about your gut feeling on something, because you have a lot of experience. Halfway through your presentation, you mentioned that it's a rare occasion, courts annulling one or two decisions for commission. It seems to be the norm in Turkey as well. We see rarely courts annulling competition authority decisions, although that trend is changing a bit and we see more of cancellation decisions, but it's still, the norm is like that. And in a lot of member states, I believe it's the same. So why do you think that is? I mean, based on your years of experience, is it because all these decisions are excellent, or is it because lack of technical expertise at the court level? Or is there some combination of that? What do you think about it?
That's a good question. It's first of all, I think there is something that has to do with the legal tests, theories of harm, and so on. In Article 102, the case law, the historic case law, has been quite conservative. I remember when I first joined White Case, I was working with my mentor was Ian Forrester back then. And Ian Forrester used to say, Article 102 is like the elephant and the small animals, the mouse. The elephant must be very careful not to step on small mice, right? In other words, sometimes Article 102, but that's not how we should be looking at 102, right? This is not about the elephant and the mice. Because if that's the test, then it's very easy. But that is unavoidable. It's unavoidable for judges and enforcers sometimes to think in those terms, because it's the big versus the small. And there is, I think, already, this is the special responsibility concept that we have in Article 102 in our EU case law. These were, that's how our case law started, essentially. So a lot, I think, relates to that. Of course, over the years, we have now the more economic analysis in Article 102, but still it's difficult because, it's quite complicated. It's very technical. Where you go to national courts in particular, and you go with an AC test, good luck. I mean, to persuade the judges that the commission or the authority rejected the AC test. They don't understand what an AC test is. So it's not easy. This is a very technical area.
Thank you very much. Thank you very much for the presentation. So a lot of questions I had in mind already asked, but I want to, so in the heart of the abuse of dominance lies actually the capability test where I read from. But we also have some new rules, ex ante rules such as DMA. And the concept of abuse, do you think that concept of abuse will evolve outside of the scope of the digital industry where the DMA covers, with the cases like revolving around the DMA that we're seeing when it comes to the courts? Sorry.
The DMA, I don't think the DMA will kill Article 102, because there is some people who say, we will have less and less decisions, etc. I don't think the DMA will kill 102. Certainly, currently, as we speak, there's a lot of activity with the European Commission, the gatekeepers, certainly there's a lot currently going on. But I think this is because this is normal, because these are the first stages, the early stages of the DMA enforcement. So the Article 102 will continue being there, and Article 102 also will be used always as a kind of experimental tool to see, let's start with ex post first. Let's see how ex post works, for example. And if it doesn't work, then we can think about ex ante. So it will always be the case. Of course, 102 is very different from the DMA, because 102, as we know, is a very flexible tool. It's based on a general clause, abuse of a dominant position. So very general clause, right? And then you can develop it as you want. Whereas the DMA has 21 inflexible obligations, 1, 2, 3, 4, 5. Of course, in each of these obligations, there is a lot to discuss and interpret, but still. So I think that the 102 will still be there. It will be used in new cases. We see new theories of harm more and more these days, self-preferencing, for example, denigration cases in the pharma market, etc. These are new cases, right, that you couldn't do otherwise. So I think it will continue being a very interesting area, giving to all of us the opportunity to study it and to work on it.
These are all we have, all the questions. One more, very quick one, okay? Because we're already late.
Thank you for your presentation. In case of pricing, there's a free to use in the general social media and digital markets, but these markets also two-sided markets, and there's an advertising and database monetizing in the other sides. So is there a way to use this advertising price or other things to use as a pricing metric?
First of all, the Android case had a pricing element, although it is a digital case. But this was an old school type pricing element. So what you're saying is, how can we apply numerical tools when we are dealing with zero price markets, etc.? The economy is very easy for the economists to deal with that because they can build models. Even in a zero-priced market, I mean, they can very easily build models. The problem is, it's not an economic, I think, issue. The problem is more a legal issue. And I go back to what I was explaining before. There is this fundamental categorization and distinction between pricing and non-pricing cases in 102. And there are the behavioral cases and the pricing cases. So, you know, it's very difficult for the Commission, or indeed for the National Court, for the National Court and the European Court of Justice, to depart from that categorization. In the Android and the Google Shopping, I'm not referring now to abuse, but it's relevant. We had the issue of market definition. How do you define the market in zero-priced markets, for example? And what the Commission did is they introduced not the SNP test, but the SNCC test, small but non-insignificant deterioration in quality, right? So there are ways, economic ways to do, but you know, with numbers, I'm sure, I'm not an economist, but I'm sure you can also play with numbers. It's just very difficult to find the right audience in competition authorities to listen to your arguments when it comes to those cases.
Well, thank you very much. That was an insightful presentation, and thank you for the answers. Thank you, everyone. Thank you for the questions.